Namaste everyone. Welcome to Courts This Week on Live Law. I am Tanya Pandey and every week I bring to you updates from different courts across India. To continue learning about important judgments, subscribe to Live Law and click the bell icon to not miss any videos from us. Let us begin the episode with judgments from the Supreme Court. The Supreme Court on 18th May ordered release of A.G. Perarivalan, convict in the Rajiv Gandhi assassination case, invoking powers under Article 142 of the Constitution. The apex court was of the view that the inordinate delay in deciding Perarivalan's early release plea by the governor under Article 161 warranted his release. Perarivalan, who had served 30 years in prison, approached the court aggrieved by the delay in his release, despite a recommendation given by the Tamil Nadu government in 2018 to remit his sentence. The Supreme Court on 18th May dismissed the review petition filed by Shapoorji Pallonji Group challenging the order dated 26 March 2021, wherein the apex court allowed Tata Sons appeal against the NCLAT order to reinstate the ousted chairman Cyrus Mistry. The review petitions were filed on behalf of SP Group companies, Cyrus Investment Private Limited and Sterling Investments Private Limited. The court, however, agreed to expunge certain adverse remarks against Cyrus Mistry from the judgment. The Supreme Court on 18th May allowed the implementation of reservation for other backward classes, OBCs, in the local body elections in Madhya Pradesh. The court modified its earlier order passed on May 10th, which had directed the State Election Commission to notify the elections without OBC quota, saying that the triple test requirement for local body reservation was not completed. Later, an application was moved seeking to modify the order, stating that the Backward Classes Commission had prepared a second report, revisiting its earlier report based on the observations of the court. Stating that the revised report satisfies the triple test requirement, permission was sought to implement the OBC quota. The Supreme Court has observed that the permanent Lok Adalats have adjudicatory functions under the Legal Services Act 1987 and thus are empowered to decide a dispute before it on merits. The bench of Justices D.Y. Chandrachud and P.S. Narasimha held that conciliation proceedings under Section 22(c) of the Legal Services Act are mandatory in nature. Even if the opposite party does not appear, the permanent Lok Adalat is still bound to follow this step-by-step procedure. The court observed that the main goal is conciliation and settlement of disputes in relation to public utilities, with a decision on merits always being the last resort. The Supreme Court recently struck down the clause of April 2018 notification issued by the Ministry of Home Affairs, which required private unaided educational institutions in Chandigarh to publish their balance sheets or income and expenditure account on their websites. Part of the notification was struck down by a bench of Justices E.M. Khanwilkar, Abhay S. Oka and J.B. Pardiwala while considering special leave petition assailing a Punjab and Haryana High Court's order dated May 28, 2021 of upholding the April 2018 notification. The High Court had dismissed the said writ petitions, opining that the appropriate authority was competent to issue such government order or notification. The Supreme Court has observed that when an ex parte decree is set aside and the suit is restored to file, the defendants cannot be relegated to the position prior to the date of hearing of the suit when he was placed ex parte. The bench of Justices M.R. Shah and B.V. Nagaratna in this case observed that a trial court can consider whether, on setting aside the ex parte decree, defendants' prayer to permit them to file their written statement can be allowed. The court directed the trial court to consider the issue with respect to the prayer of defendants to allow them to file their written statement. Let us now go over judgments from the High Courts and other courts. The Delhi High Court has granted ex parte ad interim injunction in favour of Burger King in the trademark infringement suit filed by it against the defendants, alleging that they were misusing its registered trademarks and also engaging in registering infringing domain names, incorporating the trademark Burger King and operating fake websites without its permission and authorization. Justice Jyoti Singh thus restrained the defendants from advertising, offering any goods or services, using or registering corporate names, domain names or pages bearing the trademarks Burger King, BK, or any mark deceptively similar to the plaintiff's trademarks. The Madhya Pradesh High Court has recently directed the trial court to issue direction against the prosecutrix in a rape case to refund the compensation she had received from the state government because she had admitted in her statement that she had lodged a false report against the accused. Deciding the bail application moved by the applicant or accused, Justice Vivek Agarwal observed that since the alleged false report was lodged, therefore she is not entitled to keep the amount of compensation paid by the state government collected from the taxpayers of the country. The Karnataka High Court has refused to quash an order passed by the controlling authority or appellate authority under the Payment of Gratuity Act 1972, which directed government bodies to pay gratuity amount claimed by former employees from the time they were employed as daily wage earners till their employment was regularized. A single bench of Justice K.S. Mudugal, while refusing relief in a batch of petitions, said that there was no merit in the contention that on their regularization into service, respondent number 1 would lose the benefit of the Act. The Calcutta High Court has held that no direction can be passed to sell property to third party in Section 9 petition of the Arbitration and Conciliation Act. The single bench of Justice Maushami Bhattacharya held that a direction to sell the subject property to an outsider who is not a party to the arbitral proceedings would result in the property going out of the girdle of the arbitration, and the purpose of a Section 9 application itself would be defeated. The court further held that a party should not resort to the remedy under Section 9 to enforce a part of the award when it has a clean and unobstructed path for enforcing the award under Section 36 of the Act. The Bombay High Court has ruled that the allegation of forgery is required to be dealt with at the stage of trial before the arbitrator. The single bench of Justice A.K. Menon dismissed the contention that an arbitration clause cannot be invoked as a result of novation of the agreement containing the arbitration clause. The court added that even though there had been a novation of the partnership deed containing an arbitration clause, an arbitrator could be appointed for adjudication of disputes against the partner with respect to the partnership form. The National Company Law Appellate Tribunal, Principal Bench, New Delhi, comprising of Justice Ashok Bhushan as chairperson and Ms. Shrisha Marla as technical member, upheld the order of NCLT Kolkata, wherein the NCLT held that a joint auction under the provisions of Insolvency and Bankruptcy Code 2016 and Sarfazi Act 2002 is permissible in order to maximize the value of the assets of the corporate debtor. NCLT, though, noticed that there may be a procedural lapse in conducting a combined auction, but held that selling these assets together can maximize the value of the assets of the corporate debtor. NCLAT upheld the order of NCLT by observing that when NCLT is satisfied that a joint sale shall bring maximization for the aspect of the corporate debtor as well as guarantor, the suspended director cannot be prejudiced in any manner. That's all for today. I appreciate you being with us. To continue staying updated about legal developments, subscribe to Live Law and click the bell icon to not miss any videos. I am Tanya Pandey and you're watching Courts This Week. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.